If you have created a living trust, tell your loved ones about that trust. Tell the person that you have selected to be in charge of that trust where to find your original trust. And if you're the person that has been selected to be in charge of the trust and you don't know anything about administering a trust, keep watching this video in order to learn important facts about administering a living trust. Hello again, this is Certified Probate Real Estate Specialist Daryl Williams with Win-Win Realtors here in Southern California. On this program, we assist personal representatives and probate attorneys with real property that is in the probate process. So if you are new here and you're interested in this type of content, be sure to like, share, and subscribe. Let's get started. Too often, people find themselves or discover that they are the successor trustee or the person that's in charge of a loved one's living trust. Settling a person's trust estate is known as a trust administration. And a trust administration can be a stressful and painful experience if you are not experienced in handling a living trust. If you unexpectedly find yourself in charge of a loved one's living trust, here is some important trust administration information you need to know. There is a particular process you must follow. As the successor trustee, your role is to follow the written instructions of that trust. A successor trustee's role is similar to that of an administrator or an executor in a probate administration. Your job is to settle the deceased person's estate. And the key to a successful, painless trust administration is an experienced estate planning attorney. If a trust administration is simple, it could take as little as 6 to 8 weeks to administer that trust. If a trust administration is extensive and complicated, it could take years to administer that trust. A simple trust administration can cost as little as $4,000 to $5,000. An extensive, complicated trust administration could easily cost tens of thousands of dollars. What's the message here? Make sure that your trust is properly funded and properly structured. You want to make sure that all of your assets are able to go through the trust administration process as opposed to having to be probated separately from the trust. Start the trust administration process by identifying and carefully reading the living trust. Gather all of the decedent's documentation, financial information, deeds, bank statements, tax information, other records related to ownership. You will need to evaluate these assets in order to create a date of death value of all assets. The following are some of the main liabilities and responsibilities of a successor trustee. Identify and collect all assets of the trust estate. Pay all legitimate bills related to that trust estate. Pay any tax liabilities owed. Make distributions dictated by the trust. As the successor trustee, you'll need to follow the procedures and the laws of your state in order to shield yourself from liability and other legal issues. Be sure to document all transactions related to that trust estate. And you should take action immediately to begin that trust administration so you can avoid issues with the family, such as people stealing items from the estate, etc. Question of the day: have you created a living trust? If so, did you tell the successor trustee where to find the original? Let me know in the comments below. Trustors usually create living trust in order to avoid a costly probate procedure. However, it is important for you to understand that there is still considerable amount of costs related to a probate administration. The big difference is you don't have to deal with the court system if your living trust is constructed properly. Thus, less costs involved in settling that estate. If you've gotten value from this video, be sure to like, share, and subscribe. I'm Daryl Williams. This is Win-Win Realtors TV. If you have any questions for me, feel free to contact me. My contact information is in the description. This video has been for information purposes only. It is not legal advice. I am not an attorney. If you need legal advice, please contact an attorney. If you need an experienced estate planning attorney, feel free to contact me for a referral.